but everybody else is here. So Board Member Leard, if you don't mind, I'm just going to rename your name with your district number at the beginning. Can you remind me what your district number is?
7. Thank you so much.
Okay.
And we will just let's wait till 5 minutes after, which is a couple of minutes by my calculation. Yes, it is. And thank you. I can say this in advance. Thank you to all staff members, to all board members for barely 12 hours after our last meeting concluded. That is really great and professional of you to be here, and I appreciate it so much. And we will try to be efficient and honorable toward your time. Honoring, there's some word in there that I'm missing. Kathy, I can ask you this now. Kathy Helgeson, I'm assuming you're on, right?
I'm here.
I can see your video.
Can you hear me?
Thank you. Who did you have sign up for public comment?
Tracy Watson. I added. I just sent. Okay. I sent you a new chair agenda this morning, just a little bit ago.
Oh, I did not see that. I did not see that. Anybody other than Tracy?
And then I had Adam Solomon with Whitney. I don't see him on the call.
For the data request item, okay. Correct?
Okay. I will ask them to speak at the beginning of the discussion of that item. And then we'll have board committee discussion of the item. Okay. Well, let's see if our numbers have increased by 1. Angie, you'll be doing discussion of administrative rules, is that right?
Yes, I will lead that.
Okay, and that's the first thing on our agenda, right?
Correct.
Chair, I'll shoot Randy a text to see if he's having.
That'd be helpful. Thank you. And board members all, I'm going to start the meeting by asking you to introduce yourselves, just saying a couple of words about the area you represent and maybe your background, so that those listening and that are both listening actively because they're on this meeting and those that are just hearing the streaming would know a little bit more about you. So I would appreciate that. So I'm a little forewarning there. Are we streaming now, Jerry?
Yes.
Okay, then. I think we'll get started, and welcome to this new year. It has been, I can't even say enough. I could spend the whole time here talking about what an unsettling year, and just capped off by yesterday's events. And I am just glad and so appreciative that we are in this small corner of our world trying to make things better for public education. I think that's the best we can do in these chaotic times, and I so appreciate the contribution that all of you make. My name is Carol Lear, and we are all participating in the Utah State Board of Education Law and Licensing Committee, and assisted by many staff members that support the USBE. Are you saying there's no video? Somebody is telling me. Oh, Royce is saying there is no video. So Jerry, you may want to check that.
Okay.
No,
I'm not quite sure what I see everybody's video. I'm not sure.
No, I think
Jerry?
this outside person is, yes.
Can we send Randy a link? He said he didn't get a link for the meeting.
Okay, that's possible. Could Jerry or Kathy send him that link?
It doesn't look like there's a stream on the YouTube, a video on the YouTube stream. Sorry.
Are you looking at the YouTube stream, Board Member Hymas?
I'm looking at it on our screen here, and it's just there's nothing on there. I can pull it up and double check, but that's what.
I'll double
And
check
that's
that.
fine.
I'm sorry.
Oh, thank you, Jerry. Now let's just pause for a minute. And the person that sent me a text said he could hear, but he didn't see the stream. So I'm not making you the new tech person, Board Member Hymas.
Jerry, if I send him mine, will he have the same ability on voting?
Now let's just pause for a minute.
So,
Okay.
look,
The person that sent me a text said he could hear, but he didn't see the stream.
I'm
Right,
showing.
that's probably the same.
I'm not quite sure who's requesting this, so I can just double check this.
It's Royce Van Tassel, and he's saying he's seeing, sorry to out you, Royce, I'm not sure you wanted to be anonymous, but he's saying the audio is streaming, but there's no video.
Okay, I'll try to
up.
stop it and restart it. That's the only thing I can do. I'm showing a stream and
Okay.
video and everything. So let me.
So should we just hang on for a minute?
Sure, that'd be fine. Thank you.
And Jerry, if
Okay,
I send
thanks.
Randy Booth mine, this is Kathy, Jerry. If I send Randy Booth mine, will he have the same abilities?
Yes, he can get in with yours.
Okay.
He just entered.
Yes, I sent it to him just a moment ago. So yes, looks like. Board
Oh,
Member
you
Booth
got it?
is
Okay.
doing this. Yes.
Sorry.
No
I don't know where
worries.
it disappeared.
I have had the same experience. Probably all of us have had. So no worries. We're just trying to get our streaming and our audio in sync and going out to the public. So we're on pause for a moment anyway.
And Board Member
Looks like
Booth,
everything's good.
You think it's good now?
Oh,
Once again, Ange?
sorry, I was just going to ask Board Member Booth if he could tell me his district number and I could rename him with his district number at the beginning, or if you'd like to do that.
13. Thank you.
Okay. Yes, I'll take care of that.
I'm getting multiple IM saying that multiple people can see the stream, so it is
Okay.
working.
So maybe it's an individual who's not. All right, let's start again. I won't give you my impassioned intro, but welcome to the Law and Licensing Committee, and thanks to everyone who has made this happen in a difficult situation. I was again saying my name is Carol Lear. This is the first meeting of 2021, and we have some new board members, newly elected board members, and we have some holdover board members. So if I can ask you for a moment, each board member, to introduce yourself, and as I said, just tell a little bit about yourself so that everyone participating, though we're at a distance, can know a little bit about you. And I'll start, though, the co-chair of the committee, and we so welcome his participation, is Randy Booth, because he just came on. I'll let him take a deep breath and start with Cindy Davis.
Thank you.
Hello, I'm Cindy Davis.
You want to introduce yourself?
Yes, my name is Cindy Davis. I represent District 9, but hopefully help make thoughtful decisions for the whole state. And I'm a former teacher, principal. I currently work at Utah Valley University and work with budding teachers, and I'm happy to be here. Thank you.
Thank you. Board Member Booth, would you like to represent yourself or present yourself or introduce yourself? Any of those things.
We'll do that. Thank you, Carol. It's a pleasure to be with you, even at this early hour after a marathon meeting yesterday. These veteran board members are used to the long hours, and I'm used to long hours, but usually I'm in a rehearsal hall or conducting a choir, or I've been 44 years at Brigham Young University as a music professor, and I've been on the school board at NEBO, and the NEBO Board of Education for the last 16 years. I've been on the board of directors for MTech and have loved that association. I am a grandfather of 9 beautiful kids that are just the light of my life. And I just retired recently. And so a few months ago, in August actually, and so I'm kind of excited coming out of semi-retirement to join you this morning for this committee meeting, and we're going to spend our time together doing everything we can for the children and the students of Utah's public schools.
Thank you, Board Member Booth. Board Member Hymas, would you like to introduce yourself, please?
Yeah, my name is Matt Hymas. I am in District 3, which covers West Valley and Magna, Tooele County, and Juab County. I started teaching in 2008. I taught in a charter school and have been in charters my educational career. I've been an assistant director, a junior high director, and a high school director, athletic director, all sorts of different coaching. I just have been around kids and education for a little bit. So I'm excited to serve and do what I can to help our teachers and students of Utah.
Thank you so much. Board Member Klein, or committee, and if I say board member, you know I really mean committee member, and I'm not elevating us to a state board meeting, but the words interchange. So, Member Klein.
Good. Well, hello. I'm Natalie Klein. I represent District 11, which covers Jordan School District, parts of Canyon School District, and Alpine. I am thrilled to be able to serve in this capacity and represent the parents and families of District 11 and all of Utah in supporting a parent's right to guide the education of their children and support policies that are responsive to the parents in guiding that. I support teachers in being able to, and local leaders to make those choices that are best for their kids, and to promote policies here at the board that will help restore more local control and decision-making authority or capacity on their hand. I've been in family advocacy work for the last 10 years, and I'm passionate about protecting the innocence of our children, their data privacy, their mental health, and restoring freedom in education by restoring those values and principles that our founders set up that made our country great. I think that we can make some serious improvement in that area by starting from the youngest of ages, teaching those foundational principles that will help restore the greatness of our country. And I'm happy to be here.
Thank you
for having me.
Thank you so much. I'm always impressed by the breadth of experience and the depth, in some cases, of those of us who are older bring to these meetings and discussions. And I just appreciate all of you. I probably should say a little bit about myself. I represent District 7, which is Salt Lake City, where I live, and Park City. And I have been a teacher all of my life. My first job out of college was teaching at Kearns High School. I then found that job so difficult that I went to law school and have been combining the two careers for ever since. And unfortunately, Randy, I am still not retired. I also have a number of beautiful grandchildren, 7 to be exact, and I am now passionate about their education in public schools and all schools. And so I also am so grateful to be able to do what I can to contribute to the State Board of Education and public education generally. So with that, little pause. Angie Stallings, who supports the committee and is the deputy superintendent, is going to begin by telling us, giving us some background on administrative rules.
Yes, thank you, Chair Lear and board members, committee members. So excited to work with you. As Board Member Lear stated, I am Angie Stallings, the Deputy Superintendent of Policy, and support you on this committee. I also, for your awareness, Ben Rasmussen, as well as Kathy Helgeson, support this committee, and the three of us are always happy to answer questions and help you with anything you need. So please do not hesitate to reach out. So today, as a beginning, we wanted to give you a little introduction to administrative rules and help you know where to go when you have questions and maybe you want to do some research on your own. There are 2 parts to kind of the information about administrative rules. Today, I'll mostly be focusing just on how to access the rules, some of the resources that I don't think many are aware of. And part of that is due to the great work of a number of individuals who've joined us today on and other staff members who are here with us today. So Sybil Child, who's the policy legal assistant, and I don't know, Sybil, if you, when I introduce each of the 3 of these people's names, if they could put their video on so board members can see them. But Sybil Child is the policy legal assistant for our office, and she helps file rules with the Office of Administrative Rules. She does all of the formatting, updating of the rules. She is also a great resource. If you have a question about when a rule is set to take effect or how to find a rule and you're not able to get a hold of me, Ben, or Jeff, you are also welcome to reach out to Sybil, and she can answer a lot of your questions. Sybil and Michelle Miller and Leonard Brooks recently updated our administrative rules webpage to make it more user-friendly and to provide ease of access to a number of resources. So I asked Michelle and Leonard to join us today as well so that we could give them some recognition for all the hard work. I believe it took about a year's worth of work to do all of the changes that they made to the website. Michelle Miller is USBE's web developer and webmaster. Michelle, if you could just kind of raise your hand so people can see you. And then Leonard Brooks is our IT program and portfolio manager. Leonard, could you just raise your hand so everybody can see you?
I don't know what the raise your hand button is.
Oh, just
sorry. I'm on there.
These 3, Sybil, Michelle, and Leonard, did such amazing work supporting the reformatting and rework of our website and our administrative rules. So just wanted to give them a little shout out to begin this morning and to recognize their work and thank them for all they did. So thank you, Michelle, Leonard, and Sybil for all your work. So yes, little clap. So now I will showcase the great work that they did. And just to start off, if you want to go to the Administrative Rules webpage on our website, which is, I recommend you access the board's administrative rules from our website and not the Office of Administrative Rules, although they are both available, and I'll explain why in just a moment. But if you go to our website, the landing page for our website, and you scroll down a bit, you'll come to this Administrative Rules tab or icon here, and you can click there and it'll bring you to this landing page. This landing page has all of the rules the board currently has in order, starting with Rule 100, and you'll see we go down to, I think it's 927. So if you, 929, we've added a couple rules recently. And we don't have 929 rules. There are portions where the numbering stops, but you can find all of the board's rules here. You are able to find out the status of rules that are in process by going to the board status page. This is one of my favorite resources that we have. It shows you for rules that were recently amended where they are in the process. So you can see, for example, that Rule R277-100, which includes a lot of general definitions for all of the board's rules, was amended by this committee in October, was approved by the board in November, and then filed with the Office of Administrative Rules on December 1st. This rule will now be ready. I believe today is the date, actually, that this rule can take effect. If you open this rule on the published date on the board rule status, you will see that it shows the information at the top about when the first possible effective date is. And so that is actually today, after the 30-day comment period. Just as an example, I'm going to scroll down to the bottom because I know that here at the bottom we've got a couple that just show examples of things that you might see that are a little different. For example, R277-920, which was our school turnaround rule, you can see that it actually had 3 committee hearings before going to the full board, and then was also published in the Office of Administrative Rules on December 1. So if you see multiple committee meetings here under that first side, it shows you how many times that rule was discussed in committee. And every once in a while, you'll actually see committee hearings, then board review, back to committee. I believe 726 had that occur. This gives you shows you an example of a rule that was just approved yesterday by the board. You can see that it will now be published with the Office of Administrative Rules coming up. The other thing I noticed, which Sybil, was something that I was excited to see, is you can see here that the website even shows that R277-727 is a new rule that will be coming in February. So it's a way to also see it, assuming that as staff we've prepared or as we know that a rule is coming up likely in February, that it looks like this rule will likely, it could change committees depending on the board leadership, but it looks like staff anticipates this new rule coming to the board or to a committee in February. And of course, that will be subject to board leadership assigning it to standards. The other thing I wanted to show you, which is a great way to search administrative rules, is if you go to resources, I'll just remind you that a lot of the documents, all 3 of the documents actually that are uploaded to Civic Clerk today, are also here. And so they'll be available for your reference. This document here is an overview of the board's rulemaking process. It kind of explains how a rule even begins and then the whole process until the rule takes effect. It is right here. So and Jeff Van Holten, your Director of Public Affairs, has a video on the process that goes into that in a little bit more description. We're going to get that video posted on the website as well as provided to you. But again, I'm not going to go into that detail today, but if you wanted to look up more about the process itself, you could find the board's board policy on rulemaking here, as well as that process overview. But the document I wanted to bring to your attention that is a great resource is this compilation or PDF of all of the board rules. And the reason why this is a great resource is it gives you an opportunity to search. So let's say student. Now student's going to be, let's do something a little less frequent. So if we do teacher license, and then you can see every place within the rule where you can, all of the rules where it references teacher license, or let's say you want to see all of the references to online education. Again, you can then start researching, and that's helpful if you're not sure of what you're looking for, but you know a word or two, and you're not sure which rule it belongs to. Again, that is a great place to do research and find answers. So again, that's the searchable PDF of board rules. I believe that.
Angie, can I interrupt you for a second? And,
absolutely.
Ask if is that unique to the public education rules? That just allows us to search public ed rules, R277 rules. Is that right? It doesn't
That is correct.
allow us to search all administrative rules from all agencies. Is that accurate?
That is correct. It is only a searchable PDF of the board's administrative rules. If you are interested in accessing other rules, or even I will show you now where you can find the board's rules on the Office of Administrative Rules website. The Office of Administrative Rules is the office that compiles the administrative rules for all agencies. And so if you're looking for a rule from another agency, or say you want something, the Office of Administrative Rules, for example, has rules, as well as human resources. There's other categories. You can see here administrative services, etc. For education, you would click here on education to find our R277 section of the state's administrative rules. And you can see here that there's Rule 100, 101. I personally feel, and it might be because I'm biased and it's because it's the tool I use the most, but I find our board administrative rules page to be much easier to navigate and find things than the Office of Administrative Rules. But I'm sure there are others who would disagree with me and like the abilities of the Office of Administrative Rules. One thing that recently changed with the Office of Administrative Rules, until this year, the Office of Administrative Rules only recodified or updated their website about once every 3 to 4 months. And so there were many times where rules that were posted on their website were outdated 3 or 4 months. And we had members of the public or even board members and staff who were confused accessing rules here that were out of date. Our team updates the rules on our website generally within a week, if not within a day of the effective date happening. The Office of Administrative Rules did announce, I believe it was this week actually, that they now will be updating all rules within about 10 days of the effective date. So they plan, I think they did a huge, again, revamp of their website. So for those of you who've been accessing rules through the Office of Administrative Rules, you'll notice that it does look different than it used to. And I think that with all the technology changes, I think they got a new provider. They now will have the ability to update those rules much quicker. So, but it is something to be aware of. If you go to our website, to the board's administrative rules website, it will be up to date and you can feel more confident about what you're accessing. So there are other
Angie, stopping you one, Angie, stopping you one more time. Would you mind going, just because all of us can use information and then explanation and then one more time to the information, would you go again to the state board homepage and show where the icon is and how to get to that PDF? Because it's such an improvement on the opportunity to research and have a searchable database for rules. So one more time, if you would mind, not mind.
Yep. So here's the landing page of administrative rules. And it's right here under resources is where you go. Resources, click on the resources.
Under resources.
Yep.
Okay.
And then it's right here, compilation of board rules. And actually we've had this document available for probably 3 or 4 years. I think there's only a handful of us who knew it was there, though. So that is why I was so excited to show it to you today. As well as a lot of the changes here on this website have actually been around for about a little over a year, but haven't had the opportunity to display them to you. A couple of other things that you'll see here is this board rule records is also a great resource if you want to look at versions of rules from 2020, 2019, and 2018. That's as far back as we go for now. If you have questions about versions of rules for years before 2018, you would have to reach out to Sybil for that information. But it gives you an idea of, and I had chosen a rule number, and I now forget which one it was going to be, where I was going to show you a rule that had been amended in 2019 and 2020, but this is a place where you can see the different versions that the board and committees considered over the last 3 years. Oh, and I can see why I can't find 2019 because I have to go to the 2019 tab. Sorry. Takes me a minute to remember. So if you wanted to see what happened in 2019, that's what I thought. Rule 100, we usually update that almost annually because it does include the definitions for all of our rules. So you can see what happened to Rule 100 in 18, 19, and 20 here. I think the other thing, there is a tab for public hearings and shows the public hearings we've held in the past. For some reason, let me go back to the administrative rules page on our website. So if you wanted to see what public hearings we've had in the past, you could go here. And again, that goes back to 2016. And it gives you ideas for members of the public. It gives them ideas of what requests for hearings look like, public comment, etc. And I believe that was all I was planning to show you today. So I'd be happy to answer questions.
Let's see if I can see hands. I hope you can see, all of the committee members can see where you can raise your hand to ask questions. When we meet together, and maybe as we get used to meeting virtually as in this group, we can, I'm not adamant that people raise hands, but sometimes it's a way to hear from you. And I see one from Committee Member Klein. Would you please go ahead.
Yes, I just had a question for Angie. When I was doing the reading, I noticed that it said public comment period could be anywhere from 30 days to 150 days. What determines how long they actually let it go?
So the board standard is 30 days. And because the board has a very robust, I feel, process before we even file with the Office of Administrative Rules. So as you probably know, most state agencies don't have an elected board as their that is over them. And so we as staff in another agency, somebody like me might draft a rule, and the very first time the public would see that is when it's filed with the Office of Administrative Rules. But here at the State Board of Education, of course, we have the committee process, the board process, which are opportunities for members of the public to provide public comment. And so we choose to just do the 30-day public comment period with the Office of Administrative Rules, which is the shortest amount, because of that upfront public process where we really hope members of the public will engage with us and the board on the front end during the committee and the board process and not wait until it's filed with the Office of Administrative Rules. But as you saw, it does happen. It's not a lot. I would say on average, we have maybe 2 or 3 public hearings a year. We do have opportunities where members of the public do request a public hearing during that 30 days, which we just had with the statewide online education program, as you saw yesterday, when the board took action on that. So it's 30 days is the standard for our office.
Thank you. Other questions? I'm not seeing any hands. I to add to Angie's excellent presentation that I think, especially in the beginning, board members find board rules and processing board rules somewhat tedious and maybe even difficult, but that I have learned over the years that they are so important because they allow the board to do the work for public education. They are our policies that Board Member Booth and Board Member Hymas might be familiar with, that schools use and districts use. The board's version of those policies are administrative rules. And in fact, the Utah Supreme Court, and then it was codified into the Utah Code, has said that administrative rules have the effect of law if they are processed. If we follow the process that we're supposed to follow, they are just like statutes for public education. So I think I think we need to take the the role of rule makers very seriously, because they affect so many people's lives. I really appreciate the strong work, and I love this new. I am not even familiar enough with this new database and all the resources it provides. So thank you very much, Angie, for that explanation, and also to those of you who helped make this website more user-friendly. I will stop Googling R277-100 and go to the State Board website, because I think I'll get more updated information. Thanks so much, and thanks for that presentation. And I know that Angie and those who work with her are very available to answer your questions about administrative rules. I've even sent a text or called her on occasion and said, what is the rule about X, Y, or Z? And she has an amazing recall of that. And it's very, very helpful to know that we can follow the law and we can follow administrative rules with such ease. So thank you very much.
Thank you.
With that, I think we will go ahead. Ange, did you have something to add?
Well, I was just going to say thank you. And again, thank you to Sybil, Leonard, and Michelle for joining us and for all their great work to make the website so much better. So thank you.
No worries. Appreciate it.
Yes, it is helpful. And with that, we do have a healthy agenda, so we will start into that. I want to say what I've said before about public participation. When we have people who would like to have signed up to participate in this Zoom era, we have asked that they speak at the beginning of the item number, and then the committee will hear what they have to say, and then the committee will discuss the issue. And sometimes a committee member will be interested in asking a person who spoke initially, and I say occasionally, not too often, but to maybe clarify something he or she said. And so that will be our practice, because it is the committee's meeting to discuss the committee's materials, but we very much appreciate the information that others bring to our committee meetings. So if we can follow that process. So now we have a number of items. We'll start with one that has to do with a date with data sharing, and usually those experts who work at the USBE are explaining these issues to us, and then we move on. I believe, consistent with what I just said, we have one individual who'd like to speak to this particular item, and he was not on earlier, and so maybe somebody can help me know if he has now joined the meeting.
Carol, I don't see him on, but Whitney is on.
Okay. Well, we can't have public comment if he's not here, so we'll try and accommodate him if possible later in this discussion if that works. But with that, then we'll turn the time to Whitney Phillips, who's our Chief Privacy Officer, just with the brief explanation that this issue was looked at by the committee last month, and we asked for some more clarification in the agreement, and we were accommodated, and now Whitney Phillips will speak about that.
Good morning and Happy New Year. I'm Whitney Phillips, the Chief Privacy Officer. Board Member Lear is correct. The committee met on this data sharing agreement last month, and Rhett Larson is on the school safety team. He and I both had a few concerns with the amount of data that they were asking for. And so Rhett Larson and I met with Mr. Solomon, who is working at Duke University, asking him to minimize some of the data, which he was happy to do that. And so we were able to negotiate much less risky data. But to give those members of the committee a little bit of background, because they weren't there last month, this is a study that they're doing looking at the size of drug-free school zones. And Utah, which we learned this from Mr. Solomon, Utah is unique because Utah changed the size of the drug-free zones in 2017, I believe. So what this gentleman wants to do with de-identified data is almost like a time series. This is what it looked like in 2010, 2011, 2013, and to see if there is a change in 2017 with any of these factors when you either decrease or increase the size of a drug-free zone. And so that's something that we learned that Utah's unique, that we changed that size in 2017. So that's what they're asking for. It's legally permissive, but it's up to the committee and the board of whether this data should be shared.
Sorry, Chair Lear, I have a question, if that's okay.
Carol, we can't hear you.
Oh, there we go. Thank you. Sorry, I could not unmute myself. My button was being stubborn. Yes, Member Hymas, you have a question, and then I also was saying something to the muted computer, but go ahead, Mr. Hymas.
My question, just, and excuse my ignorance, I wasn't here last month, and I'm not sure what.
No worries.
What data are they looking for? Can you be more specific on that, like what they want and how that's going to help them in their studies?
Yes, I can. Let me pull up that agreement. Really take me just a second. Let's see. Okay. So it looks like the agreement specifically is for attendance, any kind of incident data, academic achievement, and demographics. And that would be student level, but de-identified. So you wouldn't see any kind of names. So the variables of interest would be, let's see, let me make sure. Oh, it looks like it was 2017. It would be from the years 2005 to 2019, grades 3 through 12. It's quite a bit of data, but it's de-identified. But they're looking at, it looks like a change in 2015 that changed the size of drug-free zones from 1,000 feet to 100 feet. So it's quite a bit of data.
And a follow-up, if I could, is this?
Please.
Is this data useful in what way? I'm sorry.
That would be a question for Mr. Solomon, but if I were to guess, the data, the analysis that he would do would show if there is any kind of effect, or at least, a size of an effect to these factors if you change a drug-free zone. Are there more incidents or fewer incidents because there's a change? Because apparently in other research that he described, there is a change, a decrease of incidents when the drug-free zone is larger, an increase when shrunken down. So that's my assumption.
Thank you. Thank you.
Additional questions? Matt?
No, thank you.
Matt,
thank you.
Okay. Thank you. Whitney, I had a question. I read in the materials or in the introduction, this is de-identified, but as I read the lengthy agreement, I didn't see the word de-identified in that agreement. Did I just miss it, or is it more subtle than that?
Let's see. I'm looking at the details.
And I don't have it in front of me right now. I can do that, I guess, too.
Whitney, this is Angie. I just wanted to ask you a question. I think that our agreements are standard, meaning the provisions in them are uniform and so they're the same whether it's de-identified or not. Is that correct?
The agreements are standardized. They're very clear on. They're kind of clear on what can be used, whether the data is de-identified or not de-identified. I'm looking for the specifics in this. It does say student level. It is de-identified. It doesn't have to. Let's see. It doesn't have to necessarily say de-identified to be de-identified, but the data request does say that there is not direct identifiers. And so that means it's de-identified. So we can't have names.
And I'm sorry to be, again, a little tedious, but can you point me to I'm now looking at the agreement. Can you point me to the number, the provision number that says what you just explained?
Is that 1.10?
Let's see. I'm looking 1.10.
1.10.
Data source. I'm looking.
Thank you, Member Booth.
Let's see.
1.10. Okay. Student personally identifiable information, or PII, has the same meaning as that found. That's the definition of it. But I was looking for where in the agreement it said that it would be.
I don't see it specifically. I think we just have that it's de-identified by omission. That if this doesn't say it's personally identifiable, it won't be in there. But if you'd like to add that part specifically, to put that it's de-identified, we could do that. Let's see.
I personally would like the agreement to say that specifically, because I think it is, the data are so far reaching over the years, and what they need, what the researcher needs is specific data about student offenses and other information. So I think I would feel better if it said specifically in the agreement that the data would be provided consistent with the definition that Member Booth noted.
Sure, and it says that under number 5, data, when it says attendance, misconduct, academic achievement, demographics, because it doesn't have a direct identifier in there like SSID or a name, it's not identifiable.
And I know that's all implied, but would it be a problem for it to be expressly stated, Whitney?
No, not at all. We can add that.
Because I'm making an assumption now, but would this, sometimes these research projects don't benefit Utah, but do you believe that this would be a benefit to the families in our state and the educators in our state and the systems in our state to have this information?
I think it would be helpful to not just Utah, but to other states to know if there is an impact to changing the size of drug-free zones. That being said, this agreement does say that Utah isn't to be mentioned in any type of publication unless approved by the superintendent. And that's something that we negotiated from the last committee meeting. So I think it could be helpful.
And that also helps protect the identity of any remote possibility that a student could be identified. But I I don't know. I don't have the exact language I would put in there or the place, the where I'd put this provision. I don't have that in the moment, but I would just like it to be expressly stated that all data provided to this researcher from the state of Utah will be de-identified, consistent with Utah standards for de-identification, something along those lines. Would that be acceptable, do you believe?
Oh, yeah, I think that's a great idea. And moving forward, if you would like that a little bit more clear in these agreements, we'll put a section in there. So we'll make that a part of these agreements moving forward.
I would absolutely. My day job is sometimes working through these kinds of agreements, writing them, reviewing them, revising them. So I actually had a couple of other suggestions that I'll communicate later that are not as crucial as this, but I would like it to expressly say it's de-identified. I am now looking and seeing if any other, I see 3 hands. Member Davis.
Oh, God. Shoot.
Did you lose your train of thought? You're mute, Cindy. Cindy, you're muted.
So sorry.
There you go.
Whitney, apparently we made the change to the drug-free zone in 2015. So we've had 5 years of data since, but they're asking for 10 years prior. Seems like a lot of years. I mean, wouldn't 5 on the back end and 5 on the front end suffice? Did they give you any kind of indication of why they needed 10 years of data on the front end of that change?
They didn't. If I were to guess, just from my past experience in conducting research, is the more data that you have, the more stable you have those analyses. And so I think 5 years would be sufficient, but that it would be more stable with more years.
Okay.
More, Cindy?
No, it's just a lot. I did have one follow-up. So I guess I didn't realize, do we have written standards for de-identification? Is that
yes, we do have standards for that. We follow the NCES standards for de-identification. I can kind of send you what those standards look like. But yes,
that's okay. I'm glad we have them. Thank you.
Member Klein, you had a question also.
Yes, so I appreciate the other questions. I had those as well. And I would like a copy of the process for how they go about de-identifying. But how do we protect against, quote, incidences of data breaches with this? And it's mentioned in, 1.1 or 1.6, I guess, the issue of incidences.
Sure. We require that there's a certain level of security that folks have. You can see here on the agreement, page 5, section 40, that they need to have particular specific minimum standards. And that minimum standard is DTS's standard or higher. That's the Department of Technology. And so we require that. Duke University, most universities have that standard, and you can read those specifics there. And so we also, Utah's very unique in the fact that we have a student data privacy auditor who actually follows up and ensures and asks for documentation of this. So we actually go the next step and ask for evidence of compliance to these standards, especially with agreements that ask for so much data.
And who is that privacy auditor for Utah?
Mr. David Saleh. It's spelled Sallay, and he's listening right now too.
Okay, great. And then just one more question. Where did it go? Darn, I lost it. There it is. So under 38.5, if the data is sold, it says that it must be protected by the new owners according to the original agreement. Is there any end to how many people they could possibly sell this data to under those terms?
Let me see. 38, what did you say?
38.5. How do we know it will stay with them and not be sold to others under a similar type agreement?
Yeah, 38.4 and 5 prohibits the selling of this data. And so that's not permitted. We do follow up to make sure that after the data are used for these purposes, that they are appropriately destroyed. They will we require them to actually tell us how they destroyed the data, because it's not as simple as just deleting data, as you probably know. They're not permitted to sell the data.
It says that they're not permitted to sell for targeted advertising purposes. So what if they're selling it to another legitimate educational, an entity with a, quote, legitimate educational interest, as it refers to in 1.1?
Yeah, that 38.4 is unique to Utah code because with the Student Data Protection Act, because it prohibits, that's what it says. And so we kind of took that language. It prohibits the selling of data for targeted advertising. But that 38.5, researchers shall not sell for any other reason. It says here, with being in compliant with this. So they're not permitted to sell. That's how I read 38.5. But yeah, 38.4 is from the Student Data Protection Act.
Okay, thank you.
Mm-hmm.
Other questions? I think Member Hymas, please.
Yes, thank you. Looking over 38.1, it says researchers shall not collect, use, or share data beyond the purposes set forth in the attachments. And then jumping up to 35.8, and I apologize for jumping around, but 35.8, it talks about during the term of this contract, if USBE requests the destruction of personally identifiable information collected, generated, or inferred. My thought is, we talked about it, and this kind of goes back to Committee Chair Lear's concern about the personally identifiable information, the PII. We said that we are not going to give it, but does this not kind of insinuate that we are giving it and that we can ask for it to be destructed at any point?
Oh, that's interesting. And I'm glad you're picking this apart. This agreement took us about 10 months and 10 attorneys to get clear. But it says, you're right. This doesn't say it's permissive to give PII, but it does directly relate to this destruction of PII. But I think we could alter this agreement. And this is a living document. We always want this to be better. We can alter it to say the destruction of data, period, and not include that PII. We can just say data at all. But we do have the ability to terminate this contract at any time and request that it be deleted.
Yeah, the 35.8 just insinuates that they will be collecting PII and that we can ask for it to be destroyed. However, we're at the same time saying they are not collecting PII. So if we can fix that, that'd be great.
Sure.
And I'm sort of unclear what you're saying. saying, Matt. I agree. 35.8 says that during the term of the contract, USB can step in any time and say, destroy 2009 PII. Or you're saying something different. You're saying that the researcher would have PII to destroy. That's what you're, I think, trying to say? Is that right?
Yes, that's what I'm getting from 35.8 is that PII. We're saying that PII should never come to the researcher.
Right.
But 35.8 says that we have the right to tell them to
ask for it.
Yes, destroy it, but they should never have gotten it in the first
Which they should never have had.
Yes.
Yeah, now I understand. I'm sorry. Whitney, did you understand that the first time?
Yeah, I think so. I think we can change this 35.8 to be a little bit more broad with the destruction of data, have it be a destruction of data period, not necessarily PII. It can be de-identified data as well. So I think we can make that more clear.
Okay, so 35.8. I know it's a little confusing because we've got 35.8 and 38.5. So I think I appreciate that Member Hymas noted that because I did not catch that. Thank you. Member Davis, other questions or your hands just residual?
Yeah, I'm ready to make a motion, which includes your recommendation.
Hang on one sec.
And
hang on one second. Member Klein, I think may have had another question. Is that right, Natalie?
I do. Thank you. So I have the same issue as Matt. So thank you, Board Member Hymas. And I also have, so if it said de-identified PII, would that take care of it? Or are they two different things? De-identified is just data and PII is PII.
Well, data can be either personally identifiable or de-identified. And what's interesting is I think PII is only mentioned in that 38.5.
35.8.
35. Thank you, Carol. So I think we can change that and just refer to it as data, because data is data whether it's identifiable or not.
Could we still put de-identified data? Just to clarify.
In this, yeah, I think that would be wise to, as mentioned before, to kind of have a section at the top, I would say, and where it says, what they're asking for, to make it very clear if it's personally identifiable or de-identified. And so, and then data would refer to that. So I think we can make those changes.
Okay, and then just one other question. In 1.7, it says that metadata is used to create context to other data, that it could be created manually or automatically. What is the metadata that they're referring to in this?
Metadata is, this is just in the definition section, I believe, the 1.7. It's kind of residual data that may be behind that. Let me see if I can come up with a better definition for you.
I'm just wondering if that's stuff we need to.
I did not see, and I did not see it used in that definition, or in the document. I'm sorry, not in the definition, in the document.
I guess my question with that is, if it's metadata is being also collected to create it says create context and meaning, then to me, it makes me worry about if the study itself could be massaged to come up with their own results, whatever desired results they want. Does that make sense to me? So it makes me question the possible legitimacy of the research itself, if they can use that to create context and meaning.
Can I make a comment?
Oh, sorry.
Do you want to, and AEG Buse is on, maybe she can take a little burden off Whitney for a minute and speak to to speak to that question. Michelle?
Yes. So when you're looking at the general terms and conditions,
Right.
we're looking at right now, those
Right.
are put into place for every contract that deals with student data. And so the only terms of it that apply specifically are the ones that are named in the attachment that comes with it. And so this researcher did not ask for metadata. And so metadata would not be provided to him. So metadata is only going to be provided when it is a part of the attachment that comes with it. Metadata would show the date that it was taken. It would show the location that it was taken. So it's those sorts of little codes that come with like an email or that come with an answer that a student gives that tells us where it was taken from or the date that it was taken. So like on a fax machine, the telephone number that it was taken from so we could track it down, or the IP address. So those things are metadata, but he did not ask for that. And so metadata is not applicable here. And then another thing is we can't change the terms and conditions to be always be identified data, because we have vendors that handle identifiable data. We have vendors that help us with student assessments. And when they are handling student assessments, they handle identifiable student data. So every contract that we deal with, we can't change this general terms and conditions to always be de-identified data. So it would be better if in the attachment that is specific to this researcher, that's where the language says de-identified data instead of changing it in the terms and conditions. There was a reason why it said data and PII in that section. And that was because there are different contracts. Some of them only have de-identified data, but some of them have PII. And so there was actually a purpose for those two different terms to be in that section. So I hope that that helps clarify that there was a reason for every word to be in that general terms and conditions. So if we want exceptions, those exceptions should be in the attachment. I hope that that helps a little bit.
Very helpful. Thank you. It helps me.
Thank you for letting me speak.
I didn't read it that way, and I appreciate that very much. Does that change your comfort level, Member Hymas?
Yes, the clarity. First off, thank you, Whitney, Michelle. We are hurling questions at you, and you guys are answering them very well. Thank you.
Thank you.
My only thought was, I get the verbiage and I understand that. I just want to make sure that what we're saying doesn't conflict with what we're giving. So if we are not giving PII to the vendor, great, because that's what we're saying. But then in the terms and conditions, it was worded a little bit confusing on 35.8. But if we are sure that they are not getting the identifiable information and not using that, then that's great.
Generally, the attachment should start with language that says anything in this attachment supersedes the terms of the general terms and conditions. And that way, every specific thing that you ask us to put in that attachment that you feel should be special terms for this researcher, they would trump anything that is in the general terms and conditions. So the concerns that you have about this specific researcher asking for a lot of specific information are valid concerns. And you should be able to say at the beginning of his and say to him, you need at the beginning of your request to put these terms and conditions supersede all of our general terms and conditions. And for us to be comfortable, we want you to have this and this and this. And as board members, that is your prerogative. You can ask for that to be put in there.
Thank you.
Thank you. Thanks for that clarification, Michelle. Brian, another AAG is also adding his comments.
Yes, just
Brian Quisenberry.
Hi, thank you. It just took me a little while to do a keyword search on this agreement, but the word metadata only comes up once, and that's in paragraph 1.7 I see it as a stock definition that is just there in every single one of these terms and conditions addenda, but otherwise it's not used, it's not requested. So, which tells me that it's not kind of in play with this agreement.
Thank you. Helpful also. So I think, and Michelle, your hand's still up. More? I see no further hands except Member Davis.
I have a motion, but may I ask a quick question, Chair?
Yes.
This is for AAG Buse. Is it possible why don't we put that qualifier on every contract that the specifics supersede the generals?
When Zach is in charge of it, it usually is. So where the outsider provided it to us, we just didn't require it. So when you make your motion, you could say, my motion is that we accept it with the amendment that it begin with this, that language, and Whitney and I can work together and put that language in there for you.
Okay. So I've crafted a motion that I sent to Kathy. So at the end, maybe help me add that in, if you will. Okay.
Go ahead then, please. We'll hear your motion.
Okay. I texted this to you also, Chair Lear. I move that the committee recommend the board approve the proposed Duke University research sharing agreement for the years 2010 to 2020 with standards for de-identification language added to the contract, and in line 35.8, changing the word identifiable data to de-identifiable data, and adding that
the terms and conditions of this amendment supersede any conflicting provisions in the general terms and conditions.
Kathy, did you do that? Just making sure that somebody recorded. I don't have it, but Kathy might have.
And I have a question.
And I have it recorded.
Thank
Okay,
you,
great.
Kathy.
And I have a question, a clarifying question for the maker of the motion and possibly Michelle Buse. In your explanation of the attachments, would you say it was still necessary to change 5.8 if that clarification exists in the attachments?
No, because Cindy already put that de-identifiable language in there, but it's okay if it makes you feel more comfortable. It's like saying the same thing twice.
Okay, all right. Then we'll leave it like that. So,
and it also gets rid of the inference that board member Hymas had pointed out.
Hymas,
it just helps.
Good point.
Around.
That is helpful. Thank you. I didn't get the very last phrase of that, but I will repeat the motion and then somebody can help me with the very last phrase. But the motion is that the committee recommend the board approve the proposed Duke University research sharing agreement for the years 2010 to 2020 with standards for a de-identification language added to the contract, and in line 35.8 or in section 35.8, changing the phrase, and so I'm changing this as we go a little bit, Cindy, sorry, identifiable data to de-identifiable data. And I don't have the rest of that. There was another phrase,
and that
Michelle,
the terms and conditions of this amendment, and I don't know if it's addendum or amendment. We'd have to look at it.
Okay.
The terms
and
terms and conditions.
Okay. and that the addendum or amendment to this agreement provide language that supersedes those additional terms supersede the general terms and conditions.
When in conflict.
Yes, when and if in conflict. So I know that was a little bit of a messy restatement of your motion, but I think that Kathy and Angie together can make sense of that. So that's the motion before the committee.
Committee or not?
I'm sorry, go ahead. One more time, Randy.
No second is required in committee, is that correct?
That's correct. Thank you. Thanks for that reminder for all of us. So with that, I'll put that motion to a vote for the committee members. And you can just raise your hands and I will see those on your computer. Well, I will see them also if you raise them personally. And I think, yes, the vote is late and the vote is unanimous in the affirmative. Thank you very much. Remember to lower your hands. Randy, did you have an additional comment?
No.
Okay.
Thank you.
Thank you very much. Moving on to the next item, which would be item 1.3, educator and action item R277-505, education leadership license areas of concentration and programs. This is a repeal. Mr. Rasmussen, would you like to address that?
Yeah, just if I may, Ben Rasmussen, Director of Law and Professional Practices. This is a case where the board adopted a rule R277305 in August that adopted a new school leadership license area. 505 has become obsolete and we just neglected to repeal it. And so we're asking the board to repeal that rule.
So would somebody like to make a motion? And I have Cindy Davis, who has maybe her hand up still or would like to make a motion. Member Davis.
I move that the committee repeal R277-505 on first reading and recommend the board repeal the rule on second and final reading.
Thank you. The motion is that the committee appeal R277-505, education leadership license areas of concentration and programs on first reading and recommend that the board repeal the rule on second and final reading. Are there any questions or discussions to that motion? I see none. Would the committee members please vote? And I see that all have voted in the affirmative, and so that rule can be recommended to the board for repeal. Mr. Rasmussen, item 1.4.
So this is another similar situation. R277506 is now obsolete because of the passage of R277306. Again, just seeking a motion to repeal this obsolete rule.
And Member Davis, you have a motion.
Here. I move that the committee repeal R277-506 on first reading and recommend the board repeal the rule on second and final reading.
Any discussion to that motion?
I love the quick ones.
I see, me too. I see no discussion. The motion is that the committee repeal R277-506 on first reading and recommend the board repeal the rule on second and final reading. Would the members of the committee please vote? And I see that all have voted in the affirmative, so that rule will be recommended for repeal to the board. Now we have a series of, no we don't, we've got one more, item 1.5. I think again, Ben Rasmussen with support from Jennifer Thronson and Cammie Dupre. So
thank you,
go
Chair.
ahead, Ben.
So R277308, we just primarily have one substantive change to this rule. You can see it on your screen on lines 24 through lines 27. This deals with LEA induction programs for new licensees, and staff recommends changing the plan for how an induction program should look. The language there is in front of you, and if you have questions about the reasoning for that, Cami Dupree and Jennifer Thronson would be able to answer your questions on that.
I would personally appreciate a brief discussion of that from one of them, if they would be willing, either Director Thronson or Ms. Dupree. Either one of them, are they on our discussion right now? Yes, Cami, I see. Cami, would you like to give us a little more substance and additional information about that?
Yes, thank you. I apologize. I just dropped my daughter off at school, so I'm on my way home. So.
I hope that's okay.
Yeah, it's good. The language that was originally written into the rule talks about a professional learning plan. And that plan, that particular language has been used in the past with regards to some licensing requirements, and is currently in use in terms of the Apple LEAs who want to create an Apple program within their LEA to an alternate preparation path for licensing. And that professional learning plan in that context has become more or less a checklist of these are the courses or classes that an educator is going to complete in their preparation phase. So we wanted to revise the language in this rule to steer clear of any kind of confusion related to licensing, to sort of separate or help separate that what's happening with regards to induction shouldn't necessarily be tied directly to licensing. And so that's the reasoning or the history behind why.
I appreciate that clarification. And just to make sure I understand what you're saying about separation between ongoing support and licensing, but are you also saying that a professional learning plan is not necessarily the only way that happens? Is that what you're also saying, Cami? Or I'm missing the point.
Can you hear me okay?
You can, yes, and you can tell me if I'm missing the point, but go ahead.
No, I don't think you're missing the point. This is partly the reason that there was so much confusion around it. I think the original intent in the language was around professional learning, and that there will be support within induction programs for the ongoing professional learning of beginning educators. And that is still the intent to support that. The actual language, however, as it had been used, was leading people to think about a list of classes to take. And so in the revised language and the use of terminology to indicate or to help LEAs sort of flesh out what those plans might include, we've embedded language that supports what should be happening as part of mentoring efforts with beginning educators, that they should be engaging in reflection and goal setting and kind of that maybe not formal professional learning only, but informal professional learning as well as they engage in their mentoring experiences. I don't know if that helps answer your
Okay, I think that helps. It does. It does. I just wanted to make sure I understood. I have like to hear from Jennifer Thronson if you have something to add, and then we have several board members with questions. So stay tuned, Amy. Jennifer.
Yes, Jennifer Thronson, Director of Teaching and Learning, and in coordination with Cami on this, I think the piece to pick out is in section 1. It talks
Get closer to your mic, Jennifer.
Oh, hold on. I'm going to just fix it so you don't have to deal with that today. Okay.
That's important. Go ahead.
Hopefully this is better. Okay. This applies to not only those associate educator licenses, which would be our Apple program educators, but also our professional licensed educators within their first 3 years. So the trick with the professional learning plan in the other rule is it's only for those associate licensed folks, and really attends to what Cami was articulating, the coursework and the requirements needed to earn licensing, where this is about professional development and growth on a more broad scale. And so it can account for, like, yes, you need to take these courses, but we're also going to support you in, maybe you're struggling with classroom management and you've asked for support, those types of things. And so this is a really more personalized plan related to their personalized needs, rather than the needs that every educator is required to meet through their professional learning plan in their Apple program.
Okay, I think that helps me understand. I see some other questions. Member Booth?
I just wanted to say that I'm very excited from the perspective of a local board member, or for administrators who are developing those plans in support of the development of an educator. I think these specific words and ideas clarify and make it very easy for them to come up with that personalized plan. And I feel very good about the changes.
Great. Thank you. Member Davis?
Yeah, I wanted to point out a couple of things. One, these things that we're asking for here, it's not like adding one more thing to someone's plate, because theoretically, these are the things that should be happening with the formative and summative evaluations. And these summative evaluations should be happening each year with folks in the induction space. So they should dovetail quite nicely with what they're already doing there. And then the other thing I just wanted to say is that I have felt so strongly through the years that we talk a lot in our state about recruitment and retention strategies, but we have this almost vacuum in the space of induction. And I've talked to Cami about this a little bit too, but so I want to thank you for your efforts in thinking about induction and focusing on ways that we can support these new professionals better. And Chair, I'm ready with a motion whenever you and the committee are ready.
Let me check and make sure. There are no other questions. Thank you, board members, for your comments and questions. And yes, Member Davis, I think we're ready for a motion.
I move that the committee approve R277-308 Draft 2 on first reading and forward to the board for approval on second and final reading.
I keep moving around when I ask for comments or questions, but any other thoughts, questions from board members on that motion? Then to repeat the motion, it is that the committee approve R277-308 Draft 2 on first reading and forward to the board approval on second and final reading. Board members or committee members, please vote. And I see that. I'm looking for one more. Hi, Ms. Booth, Davis, Klein. I voted. Oh, there we are. And the vote is complete, and it is unanimous. And thank you very much for your preparation and your participation, Cami especially, and Jennifer. Thank you very much for what you added to that discussion. Now we're moving on to a number of rules that have to do with professional practices that have a continuation element, and in some cases an amendment element. And I know we have at least one person to speak to this, and as my understanding was that she wants to speak generally to these And so I would like to hear from her first, and then I'll turn the time to Ben Rasmussen in fact, let's have Ben maybe introduce these rules so that we'll have a little greater clarity, greater background than I gave. And then we'll ask the one person who signed up to speak generally to the rules or make whatever comments she has in mind. And Tracy, because it's a number of rules, you'll have about, if you can keep it under 5 minutes, that would be great. So Ben, would you like to introduce these first?
Sure, thank you, Chair. So the rest of the rules, I'll deal with the Utah Professional Practices Advisory Commission. Most of these rules had some heavy amendments during a task force that concluded a little over a year ago. And the one thing, though, was that in the motions that we made in changing a lot of these rules, the rules were not continued. So for those of you that are new to the rulemaking process, rules are effective for 5 years and then they sunset unless they are continued by the agency that makes the rules. So the first 3 rules that are on the agenda, we simply are requesting a motion that the board continue the rule, meaning give it another 5 years as is, unless the board does something later. But on 210 through 212, we are simply requesting that the board continue the rules. I don't know if, Chair, if you want me to go into the details of the other rules right now, but we do have some proposed amendments to the other rules that I can talk about at whatever point, Chair, you'd like me to.
Thank you. Let's hear from Tracy generally, and then we'll make that decision after we deal with the first 3 that are just continuations. So Tracy Watson had signed up. Tracy, General Counsel for the UEA, and you'll reintroduce yourself, but would you like to speak to the rules generally?
Yes. Carol, can I ask you just 30 seconds? My tenant is locked out of her house, and I have to open her.
Okay, thank you very much. Go ahead. We'll wait.
Chair, can I ask a question while we have some space?
Of course.
While we're waiting,
go ahead.
Would it be appropriate after we hear the public comment, since the first situations, to make one motion for items 210 through 212, or do those need to be made each one separately?
And I'm flattered that you had asked me. I would deflect that to Angie. Is that an appropriate motion for those 3 first rules that just need continuation?
Yes, you can make one motion on all 3, but then what we will do is we will reflect the committee's action separately for each of those, 210, 211, and 212 in the meeting summary. So Kathy, we'll just have one motion, but then with the assumption that there'll be an individual motion for each of the items when it comes out to the full board.
Thank you. And while we're still
so that would be an efficient way to go. Let's see if Tracy's back. Tracy, are you back?
Yes, I'm terribly sorry.
I'm sorry for your.
That was going to happen. Was
no problem. Go ahead. Would you like to speak again? Sorry to catch you.
Yeah, no. My name is Tracy Watson. I'm the General Counsel for the Utah Education Association. Ben sent me these rules back in December, leaving plenty of time to review them and comment, and I really appreciate that. Of course, I didn't take advantage of that time. Like most lawyers, I just waited for the deadline and then reviewed them. So I'm just going to make some general comments. Ben explained to me that on 210, 211, 212, they're just being continued. He's got some minor changes to 215, 216, and 217. I completely understood those changes. I have nothing I can add to that. The 2 I want to bring to your attention is R277-213 and R277-214. And, you know, at some point, I think Law and Licensing Committee may need to be sort of brought up to speed there was a UPAC task force that met for several months to review the rules and to make substantial changes to the rules. And their work was presented to the state board in, if I'm right, about October of 2019. And those changes in the rules took effect about January or February 2020. And one of the recommendations that was accepted by the board was that UPAC collect ongoing data regarding educator misconduct and LEA reporting and discipline, and that the task force reconvene approximately 1 year from the effective date of the new rules. Well, we're sort of coming up on that 1 year anniversary, and at least with regard, I would suggest that both that 13 and 14 can continue, but that 13 and 14 maybe should also be reviewed by that task force when it reconvenes, because the changes to 13 are pretty consequential and sort of legally tricky. There's already been a legal argument over relevant evidence as it relates to R277-213, and that legal argument was at a UPAC hearing. The hearing officer ruled in favor of UPAC, but the legal argument has not yet been reviewed by a court of law, nor will that legal argument be reviewed by a court of law. But there is a question about what should happen at a reinstatement hearing, right? The discipline is imposed either by agreements or by board imposition up front. And then the reinstatement hearing really is about how the educator rehabilitated and their likelihood of success in the future. And you can see that yourself in R277, 213, section 2, and then subparagraph 4 and B, where it says the educator, I mean, I'm sort of surmising, but what they're looking at the reinstatement hearing is, did the educator abide by the terms of the consent decree? Did the educator complete the rehabilitation plan that was imposed? And did the educator satisfy the hearing panel that she has a successful plan, that the misconduct won't be repeated? Whether or not a victim testifies to that or a parent testifies to that, it really wouldn't go to that rehabilitation section. On the other hand, I think it is important that a victim be able to testify or give notice that the teacher wants to be reinstated, or that a parent be able to testify. The question to me is that evidence relevant? And if it isn't relevant, how do we allow irrelevant evidence to happen at a reinstatement hearing without it having an effect on the outcome? Because if irrelevant evidence has effect on whether or not the teacher is reinstated, that's something that would have to be challenged beyond USBE, and that's what I'm trying to avoid. And so my ask on 213 is that it be continued, but without the changes, and that we move forward to bring the task force back together to discuss it. On 214, I sent late last night, and Ben had a long day yesterday. The country had a long day yesterday, and then he had to be back at it. I don't even know if Ben went home yesterday, but I don't know if he wants to address any of those individual questions I had about 214, or if you want me to go through them. I'm probably close to my 5 minutes. So, Carol, how would you like me to?
Thank you. I was just wanting somebody to help me with the 5 minutes because I didn't set a timer. So thank you. I think you were close. Let me pose this, and then if the committee feels good about this, or let the committee weigh in about how they feel about what I would propose. I would like to continue the first three rules, and we talked about doing it in one motion, and then unless the committee would like to hear more right now, I would like to propose that 213 and 214 are delayed until they can be discussed by the task force. And then I would like to have Ben speak to the more minor changes that are in the last, I think, 3 rules. And that's the way I would like to do it. Could committee members who feel differently, and it looks like Cindy has her hand up, other committee members, if you feel differently or you would like something different, I would appreciate you offering an alternative. So, Member Davis.
I don't know that I have an opinion one way or another, whether we, unless there are time elements involved, that we need to address 213 and 214 today. And I don't know how extensive the public comment or concerns are with 214, but so I will defer to you and the committee for your choices there. But I am ready for a motion on 210 to 212.
Okay, and I misspoke somewhat. I would like to continue. I would propose that we continue 213 and 214. So there's no chance that they would lapse, but that we could have a more robust discussion of them in a task force meeting, not go through line by line about the concerns today when this task force has the timely opportunity to meet and discuss the rules more comprehensively. So I wanted to say that I would like to continue those 2 rules, which would, I think, deal with the timeliness element. Member Hymas, let's hear what you have to say.
Yeah, I agree with your original statements, Committee Chair Lear, on 210 through 212, and then also 213 through 214. I do have just a verbiage change suggestion for 213. I don't know if right now is the time to do it, but I did want to offer that when the time is right.
Thank you. That would be super helpful. Let's deal with the first continuations and then hear your comment 13, and then we can also vote on that more formally, and also if anyone else has any comments to take to the task force discussion, which I'm assuming would happen in the next few months. And no, I think no one is placing any blame or concern that there wasn't more sort of a notice of this task force reconvening because of the year we've had. We can use that excuse for quite some time. So I certainly don't intend any blame. I completely forgot about it, and it was very central to my life for 6 months. So I appreciate those of you who brought it to my attention. So Cindy, let's have the motion on the first 3 rules.
Chair, I thought I saw Ben indicating he wanted to make a comment. I don't know if you want to allow that prior to this motion.
Yeah,
I would, and I'm sorry. Yes,
neither Ben or I are able to raise our hands because we are hosts, which makes it very awkward for us, and I apologize. But I do believe what I think might be helpful is to just move on the continuation of 210 to 212. My guess is Ben would like to speak to your recommendations on 213 and 214, but I also don't want to speak for Ben, which I apparently just did. But I did want to make you aware of the fact that Ben and I have a hard time inserting ourselves because we cannot raise our hands. So if you see us kind of going like this or turning on, I'll turn on my video when I would. Hopefully that'll help.
Great. I'll try to watch for that, and I'm happy to have Ben make comments about 213 and 214. I will find it difficult to get partway into it. That's my reservation. So if in deference to him, because he's done a lot of work on these, I'd like to hear from him on those 2, but I'm reluctant to have a partial discussion because I could spend several hours, as I'm sure some other committee members could once we get into the discussion. And that's what I was trying to delay for a later discussion when we really can spend as long as we need to. And we really should, but we'll have another opportunity. So with that, thank you. And Angie, just turn on your video because I can't even see, using my iPad today, I can't even see all of the participants. I'm just seeing the names. So with that, Member Davis.
Okay, so you don't want Ben to speak now?
No, we'll wait till, we'll do the first three and then hear from Ben on 213 and 214.
Got it. Okay. I shouldn't have eaten this chocolate nut right then. At the time with Ben. I do want to, just quickly, if I can, Chair Lear, make a note for our new committee members. And they may know this already, but when I'm making these motions, I'm simply reading the recommended action on the agenda document. So you may see those. I remember my first meeting coming to committee thinking, how does Brittany Cummins know how to make all these motions exactly worded? Well, she didn't. Just reading the good work that the staff had done. And then I'm trying to synthesize your comments as we work through the agenda item into whatever's already provided in the recommended motion. So I'm just reading under recommended action on the agendas for anyone that. And sorry, everyone's probably brighter than I was my first day. Anyway.
And let me just add to that. If a member has a different motion, there is nothing sacred about these recommended motions. So you can certainly interject a different motion, and we would all appreciate that. So thank you though for that explanation.
Yes, and also for committee members, if we're uncomfortable with the rule or we just don't want it at all, you can just not make a motion and then it doesn't move forward. So there are a variety of options, but I'll go ahead with this motion. I move that the committee continue R277-210 through 212 on first reading and forward to the board for continuation on second and final reading.
Thank you. Comments to that motion before I repeat it? I see none from committee members. The motion is that the committee continue R77-210, 211, and 212 on first reading and forward to the board for continuation on second and final reading. Would the committee members please vote? And I see that all have voted and all have voted in the affirmative. So thank you very much. With that, let me turn some time back to Ben Rasmussen to speak. And I don't know if you want to speak separately, Ben, to 213 and 214. You probably do. But I would really ask you that, because it seems we have this time for the task force to discuss these in more depth, that maybe we don't get into extensive discussion. That would prompt other discussion if we are going to leave them to the task force anyway for the first bite at that. So go ahead, Ben.
Thank you. So on 213, I'm comfortable with that recommendation if you want to send that through the task force when it's reassembled. That's just something that we feel needs clarifying, and so if you want to do that through the task force process, I'm entirely comfortable with that. With regards to 214, that would, I think, be a little bit of an expansion on what the task force was convened to do in the first place. The background check process is what 214 covers. That rule hasn't been updated in quite some time. That process was never discussed during the original task force, and it seems to me a little bit beyond the purview of what the task force was intended to do. I might propose on that case that we maybe delay action on it for a month, see if I can meet with Tracy and with the AGs and talk through some of her concerns and see if we can clean up the amendments a little bit and bring that back maybe in February. That would be my suggestion on 214. I do think that one could use some attention sooner rather than what the task force probably will convene. But I'm happy to follow whatever the course the committee wants there. So that would be my thoughts just on those two rules specifically.
Thank you. I think those are very fair suggestions. Are there any committee comments to Ben's comments? Committee member comments? As you think about that for a minute, I would propose, Ben, a sort of a broader middle ground that says that we can discuss that and do either. That we could either have a discussion, and it might be both. That we can either have a discussion, a further discussion with stakeholders on 214, or if it seems appropriate, with that discussion, to have the task force address some of the issues, that might be a possibility too. So if we could leave it that broad, I would fully support that, because I might be persuaded that a stakeholder discussion could be more efficient than a task force discussion. So is that something that you would be willing to entertain, or that you would feel like was a reasonable middle ground, Ben?
You're the one that determines reasonable here. I work for you.
Well, I like things defined, so I probably wouldn't be comfortable defining reasonable in my own view. But if it sounds like something that, okay, that's what maybe comfortable is easier to define. So I appreciate that suggestion. I'm looking for other members. Member Davis, I don't know if you have Member Hymas.
Yes, thank you. I just want to go back to Rule 213 for just a second. I see that I see that there has been a verbiage change from the word family to parent, and I prefer legal guardian or guardian. Just in my experience, parents aren't always the legal guardian.
Just briefly, Chair.
And I'll let Ben respond to that. We do have a stock answer for that. Go ahead, Ben.
Just so you understand, Member Hymas, if you look in R277-100, that's our definitions rule. Whenever we say parent in rule, that includes a guardian. So that's kind of a defined term. We actually talked about whether that should include guardian with my attorneys, but that's a stock term, and that includes the guardian.
So we're covered.
Yes.
Perfect. Thank you.
And that was your comment, I'm assuming, in about 213 that you wanted to add earlier. Is that right, Matt?
That is right. Thank you.
Thank you. So with that, I'm looking for other hands raised. Hands raised. So
I think it would be appropriate to take no action on those rules, and I'll bring them back.
I'm sorry?
Would it be appropriate just to take no action on those
rules? And I'm sorry. Yes, and I'll make that motion. I'll make that motion because I set this up and it doesn't follow our script so nicely. So I move that the committee defer R277-213 and R277-214 for further discussion, possibly with the UPAC task force, possibly with stakeholders, as seems as appropriate. Is that an okay motion, Angie?
Well, my suggestion, I apologize, did you already make a motion to continue both 213 and 214?
Oh, no, I did not. Let me.
I don't think we need really any action if we're just going to talk about it with stakeholders and bring it back next month. And then we could address at that point whether we want to just defer it to the task force or we could continue at that point.
Okay.
So we don't need a motion.
213 and 214, because I thought maybe we wanted to continue 213, but
it sounds like I would suggest we just take no action this month and see where we're at next month.
All right. So we don't need a motion to take no action. Is that correct?
Correct.
Correct. You just move on to the next agenda item, which would be 215.
All right. Without any questions from committee members, we will just move on to, we'll just skip over 213, R213 and R277-14 and proceed to R277-215, where Ben will then enlighten us about what more minimal changes are in R277-215. Please, Ben.
Thank you, Chair. So R277-215 is our UPAC presumptions rule. One thing that we have that is not covered currently in the presumptions is what happens if a teacher commits murder. This is something that shouldn't come up too often, but ironically, we do have a case pending where we are dealing with that very scenario. The staff recommendation is on lines 25 through 29. It would be that the board add a presumption that a teacher or an educator would be revoked if they're convicted of a violation of any of those 4 sections of Utah code. Those are aggravated murder, child abuse, homicide, and manslaughter. So recommendation is basically if a teacher kills someone, they can't teach anymore.
Thank you. And just for the clarification maybe of other committee members, I noted that it says convicted of, and we also, in our definitional rule, a conviction includes a plea in abeyance. Would that be accurate, Ben?
Yes.
Did I say that right?
Don't think they give too many of those on murder charges.
I'm sorry, I didn't hear that last. What?
I just commented, I don't think they give too many pleas in abeyance on those charges, but yes, that would be accurate.
That's probably true. Yes. My non-prosecutorial background speaks to that. Thank you, Ben. I don't see any questions from other committee members, but I did want to note that, there was something that Board Member Moss said in the meeting yesterday that reminded me of this, but never mind, I'll ignore that from now. I've been known to misquote. So do we have a motion on R277-215?
I can make a motion.
Thank you, Member Booth.
I make a motion that the committee continue and approve R277-215 draft 1 on first reading and forward to the board for continuation and approval on second and final reading.
Thank you. Any discussion to that motion? I see none. So the motion is that the committee continue and approve R277-215 draft 1 on first reading and forward to the board for continuation and approval on second and final reading. Would the committee members please vote? And I see that all have voted and all have voted in the affirmative, so it's a unanimous recommendation to the board. Thank you very much. Ben, would you like to speak to 216, R277-216?
Yes, thank you, Chair. So R277-216 is our surrender rule. This is a rule that permits an educator that's under investigation by UPAC to essentially surrender their license and quit teaching permanently, basically circumventing the investigation process if they don't want to go through that. This was adopted just under 5 years ago. In practice, I think it's worked fairly well, but it is up for continuation. We have recommended a few technical changes. Those changes deal with when an educator can submit a petition for surrender, and also just update some terminology, taking out reference to the term of stipulated agreement, which we don't use in board rule anymore, and which we don't really use in conjunction with the surrender anyway. So we're requesting that the board approve the continuation with those amendments.
Am I seeing any discussion to that?
Got a couple hands.
Am I seeing any committee discussion to that explanation, this rule? Member Hymas.
I just have a question. If somebody does surrender, I mean, obviously we still track that and make it known to other states. But without the entire hearing process, like how does that look? Do we just make a note saying these are the charges or these are the accusations, but they've surrendered? I mean, so the NASDAQ database, which is how we report to other states, doesn't, as I recall, doesn't really have a surrender option. And we also have some statutes that frequently require that we classify some of these cases as revocations. So what happens is these get reported as revocations in our licensing database and also through NASDAQ. Basically, it means they can't teach anymore permanently. So that's the route we report it as a revocation. And sorry, quick follow up. The permanently is for any state. That's correct?
No, it's only for Utah. It's up to other states whether they want to follow our lead. Frequently, other states will take reciprocal action based on our discipline, but we can only take action with regards to Utah, teaching in Utah.
But do they? Those conversations are happening. My concern is because honestly, I look at candidates as an administrator from all over the country. In fact, a lot of my applicants, the majority of them, are outside of Utah, and so yeah, I just don't know. I mean, if I were teaching, if I had a teacher here who just said, no, I'm going to suspend my my rights to then go to another state, is it easier for them? I mean, how do we keep them out of the classroom? Obviously, they shouldn't be in the classroom.
We routinely provide information on our actions to other states. It is very common for
Ben,
other states.
can you get closer to your mic? Ben, can you get close to your mic? I'm having a hard time hearing you, which is not usually the case.
I'm not actually sure where my mic is on my computer. I'll try and speak a little bit louder.
Okay, then just maybe speak a little.
But we do address these frequently where other states request information from us, and whenever we get a hit from another state, we just certainly look into it to see if it should affect our licensing decisions.
Thank you, Ben.
And can I add a little bit to that, Matt? That maybe some of us are assuming that board members know, and it's maybe a false assumption, and that is that there is. Ben has referred a couple of times to a NASDAQ database. This is a database that all states add to, participate in, and they put all of their educators' names in who have been disciplined with a reprimand or greater. But then it is up to the individual state to proactively check that database as the state various equivalents of LEAs hire people, just like it's incumbent upon LEAs or our state office, Ben and mostly Ben, to check the NASDAQ database status of out-of-state individuals who seek licensing here. So it doesn't automatically alert on your computer or during a hiring process. It both in Utah and out of Utah, the who's ever hiring educators has to look to that database for information. Does that add something?
Yes, thank you.
And I hope I said that all accurately.
Yeah, you're great.
Okay, thank you. I think we assume sometimes you know that, but that's why, and Ben, I agree that we can only control what happens in Utah as to licenses, but my experience is that many states, most states in fact, do actively rely on that NASTEC database, but some states make their own choices and decisions about hiring people whose licenses have been revoked. There's no federal law that says they can't be hired in North Dakota or Maine. Any other, let me look at my other, Cindy Davis. I don't know if you're making a motion or asking a question, but either.
I have 2 questions, if that's okay, Chair.
Please.
I'm quickly rereading the text to see if maybe I missed this in the rule, but perhaps Ben could tell us, if a educator surrenders, is that surrender revocable? And if they revoke the surrender, then would they go through the hearing, say 10 years later, they decide, you know, I really wasn't, I don't know, there was whatever, for whatever reason they decide they want to go through the hearing, is that possible? Or is this a one and done forever deal?
Do you want to look at lines 55 through 57? Voluntary surrender of a license is permanent. An educator who surrenders a license is not eligible for a reinstatement hearing at any time.
Okay, perfect. Thank you. I'm sorry that I missed that on my first read a week ago. And then my second question is, can you give us an idea of how often, I mean, has this ever been used? How often it's used per year, what would you say?
Since we adopted the rule about 5 years ago, I'd say we've had probably 10 to 12.
Thank you.
Other questions? Let me check the participant list. I see no other questions. Would a member like to make a motion? Member Vice Chair Booth, please.
You're muted, Member Booth.
Yeah, you might be muted, Randy.
I was saying
never muted, but perhaps
interesting and important statements at that moment. So sorry you missed them. I would like to make a motion that the committee continue and approve R277-216 draft 1 on first reading and forward to the board for continuation and approval on second and final reading.
Thank you. Other questions from the committee, a discussion from the committee? I see none. The motion is, to repeat it, that the committee continue R277-216. No, 250. Oh, this is reads wrong. I think we mean 216. Hang on one second while I gather my 216. It is 216. That the committee, I move that the committee continue and approve R277-216 draft 1 on first reading and forward to the board for continuation and approval on second and final reading. 216 is the right number. So please vote, committee members. I see that everyone has voted, and the vote is, wait, I'm missing Matt.
I voted aye.
You did. Thank you. I see it now. All members have voted and voted in the affirmative, and so that will be forwarded to the board for further review. Ben, would you like to speak to R277-217?
Yes, and this will be our last UPAC rule. I'm sure you're you're tired of all the UPAC talk by now, but we do have one more change that we'd like you to consider. This is our educator standards rule. This is the list of do's and don'ts for educators. This is a new rule that was adopted by the following the task force discussion about a year ago. We are recommending, though, a change on line 93 that would add one thing to the list of may nots for educators. That has been, we've seen it had a few cases where it's become clear that we should probably add some specifics on this. So we're recommending that it be specified that an educator may not cheat or engage in academic dishonesty, whether on behalf of a student or in the educator's own educational pursuits. I think it's common sense that an educator shouldn't cheat or be lying on behalf of a student or behalf of themselves if they're pursuing a degree in an educational program, but we just wanted to make that clear in our educator standards rule.
Ben, would you give a couple of examples of cases we've seen that then would illustrate this?
So the most recent case we had where this became an issue was we had an educator who was trying to help a student who she didn't think would be able to graduate, and so she copied some materials from other students and loaded it into to an online system to help to help a particular student meet some academic requirements. So basically cheated on behalf of the student. We also have had a case where an educator had other students take tests for students. I think that this would come into play there. The other example that it came into play was an educator that was in an educator preparation program that was engaging in academic dishonesty and cheating in his program, and that was reported to us, and so that would fall under this as well.
Thank you. I have to add one more example that I've recalled, and that is that we've had a couple of situations where counselors have changed student grades, either to raise the student's GPA, or in one case, the counselor was also the mom and changing an ACT score to benefit her own child. So that's another example. Just to throw in another really old example, once there was a district level administrator who plagiarized on a PhD thesis in order to complete and I forget whether it was a PhD or an EDD, and that was brought to the attention of the board in those days. So this occurs more frequently than you would think. Thanks for those examples, Ben. I'm seeing no further hands raised in terms of discussion or questions. Would a committee member like to make a motion?
I can do that.
Thank you. Vice Chair Booth, please.
I move that the committee continue and approve R277-217 Draft 1 on first reading and forward to the board for continuation and approval on second and final reading.
Any committee member thoughts following that motion? I see none. To repeat the motion, it is that the committee continue and approve R277-217 Draft 1 on first reading and forward to the board for continuation and approval on second and final reading. Would the committee members please vote? And all committee members have voted in the affirmative. It's unanimous. That'll be forwarded to the board. Thank you for that very efficient work. Thank you to staff who helped us last night and was available again this morning very readily. Also, I have to say a personal thank you to Jerry Record. You hear us frequently referring to Jerry, but Jerry makes every single one of these committee meetings and board meetings possible and is always helpful in facilitating, making that easier for committee members. So I very much appreciate, he's kind of a quiet guy who won't sing his own praises, but he makes all of this possible. So I very much appreciate him. And thank you, committee members. I hope that you felt able to ask questions that you needed to ask, and I hope that you will do that through the next month, and that we will meet again in a month and have another very good discussion. So thanks again to staff, thanks to committee members, and have a great weekend.
Thank you.
Any further comments? Thanks. This meeting is concluded.
Thank you.
Thank you.
And thanks for the kind words.
Oh, way overdue. Thank you.
Well
Bye.
deserved, Jerry. You do a great work. Thanks,
Yes.
Chair Lear. Have a great day.
Thank you. That went well. Thank you very much, Angie, and thanks for pass on to Ben the appreciation for the cooperation on 213 and 214. I think that would be more productive than spending a lot of time today. So
yeah,
and I bet you're hugely relieved.
No, it's great. We should probably put that issue on the committee, the board executive committee, to get them to figure out how we'd like to have that report to the task force. So,
and as I even thought about that, so many people have changed. It's going to be an interesting, and I'm still recording. It's going to be a really interesting reconvening, because we've got a lot of different personalities involved. So, but I think we do need to, the board did commit to that. So I think we should do that. Thanks again, Angie, so much.
Have a great day. No problem. Bye.